That $100,000 settlement your lawyer just won you, it's an illusion. It's a big round number designed to make you feel good, but most of it's not for you. These are two possible outcomes from the exact same $100,000 settlement. This isn't a guess, this is the math. If you want to know why one client walks away with 12 grand while another takes home over 40, you need to understand the fight after the fight. Most law firms hope you never learn about this, but in the next 10 minutes, I'm pulling back the curtain on the entire process, so stick around and I'll make sure you know exactly how to get the check you deserve. Before we get into the numbers, let me tell you about a case that came across my desk last year. A woman, let's call her Maria, was rear-ended on the 405 freeway. It wasn't a catastrophic crash, but she had significant neck and back issues. She did everything right. She went to ER, she followed up with the doctor, and she hired a lawyer from a billboard she saw every day. Her lawyer, a classic settlement mill, got her the full $100,000 policy limit from the other driver's insurance. Maria was thrilled. She thought she had won. Then she got the final distribution sheet, and the check read $11,400. She was devastated. She called me, confused, asking how this could possibly be right. We looked at the sheet together. The firm took a 40% fee right off the top. They had over $3,000 in costs for things she never approved, but the real damage was the medical bills. The ER bill alone was $25,000. Her lawyer paid it. The chiropractor bill was 15 grand. Her lawyer paid it. There was no negotiation, no pushback, no strategy. They treated her like a number on a spreadsheet, processed her file, and moved on to the next one. That's the settlement mill model. High volume, low attention, and net number that crushes clients. The good news is you can avoid it, so here's how. Forget the legal jargon. On any settlement sheet, only 3 numbers really decide your fate. The attorney's fees percentage, is it 33% or 40%? That 7% difference is thousands of dollars right from the start. The case costs, are they lean and essential, or are they bloated with unnecessary fees and administrative charges on a simple case? 3, the medical liens. This is the big one. Does your lawyer just pay the hospital's sticker price, or do they fight to cut those bills down by 50% or more? That last one, lien negotiation, is the secret weapon. It's where boutique firms win. It's a fight after the fight. You win the settlement from the insurance company, and then you have to win the recovery back from the medical providers. Most mills skip this second fight entirely. Now let me show you the distribution sheet I give every client. Most attorneys never show you this. All right, so let's run the numbers. Same crash, same $100,000 insurance policy, same $45,000 in medical bills. The only difference is the lawyer. First, settlement mill version. Gross settlement was 100 grand. Attorney's fees are 40%, so that's 40,000 right off the top. Bloated case costs, 2,500 bucks. Medical bills, paid at face value, 45,000. Do the math, you're left with $12,500. That's it. You signed the release, the money's gone, it's a tragedy. Now let's pause before I show you how we get to over $43,000. I want to highlight that medical bill number. That 45 grand is not set in stone. It's a sticker price, and you should never pay sticker price. Now the boutique firm version. Gross settlement, $100,000. Attorney's fees, 33%, so that's only $33,333. Lien case costs, let's say $1,000. That leaves us with $65,667. Now for the decisive line item, the medical liens. We don't just pay the $45,000. We audit the bills, we challenge the codes, we use California law to force hospitals to be reasonable. We routinely cut these liens by 50% or more. Negotiated medical liens, $22,500, a 50% reduction. Subtract that from the $65,667 and your net is $43,167. Over 3 times the money in your pocket. Same case, different lawyer. The fight just with the insurance company isn't the beginning. You have to fight with the medical providers, and you have to save every dollar for the client. So how do we do it? It's not magic, it's a specific legal process. In California, we have powerful tools. First, there's the made whole doctrine. In its simplest form, it means that a medical provider can't take your settlement money until you have been fully compensated for all of your damages, pain and suffering included. If the $100,000 policy limit isn't enough to make you whole, we can argue the hospital isn't entitled to anything. That's a powerful starting point for negotiation. Second, we challenge the reasonableness of the charges. Hospitals have something called charge master rate, which is an artificially inflated price list. It's not what health insurance companies pay. We argue for our client who was a victim of an accident, they shouldn't have to pay a higher rate than the major insurance company. We use billing experts and databases of what Medicare would have paid for the same services to prove the charges are inflated. Often just showing them we've done the audit is enough to bring them to the table. Third, we use specific statutes. For example, California Civil Code 3045.1 limits what a hospital can recover from your settlement in certain situations. If a hospital doesn't follow the strict rules for perfecting their lien may be invalid. Mills don't check this, we do. This is an active, confrontational process. It involves letters, phone calls, and sometimes filing motions with the court. It's work, and it's work that settlement mills are not incentivized to do because they get paid on volume, not on maximizing your net. Here's another trick that costs clients thousands. It's called medical payments coverage, or MedPay. It's an optional part of your auto insurance policy that pays for your medical bills right after a crash, regardless of who is at fault. So let's say you have $5,000 in MedPay. A settlement mill will often use that first $5,000 of your medical bills. Sounds good, right? Wrong. Your insurance company will then have a right to be reimbursed that $5,000 from your settlement. So the mill pays the hospital, and then you have to pay your own insurance company back. It's a wash. It does nothing for you. A boutique firm does it differently. We use that $5,000 in MedPay as leverage. We tell the hospital, we can pay you $5,000 from MedPay right now, cash, if you agree to waive the rest of your lien. Or we use it to pay down a reduced lien that we've already negotiated. We turn it from a simple pass-through into a tool that directly increases your net recovery. So how do you make sure you get the boutique result? Before you sign any settlement release, here's the insider checklist I give every one of my clients. Ask your lawyer these 6 questions. Number 1, show me the fee agreement. If it's 40% before a lawsuit is even filed, that's a red flag. You should walk away and never even sign with that law firm. 2, what's your lien negotiation strategy? If they don't have one or a case manager is handling it instead of an attorney, you're losing money. 3, have you audited my medical bills for errors in upcoding? Ask to see the audit. 4, how will you use my MedPay coverage to my advantage? Make them explain the flow of funds. 5, give me a line item breakdown of the costs. Ask why each one was necessary. 6, who is my primary point of contact? If you can't get your attorney on the phone, your case isn't a priority. Follow these steps and you'll protect your net recovery. It forces transparency and holds your lawyer accountable. Remember that question I asked you at the start? How much of that $100,000 do you actually keep? Now you know the answer. It depends entirely on the strategy your lawyer uses after the settlement is agreed upon. The difference between $12,500 and $43,000 is not luck, it's leverage. So if you were hurt in a California accident and you're worried about a settlement and how much you will net, I invite you to call my office for a free, no-pressure consultation. I will look at your settlement and I will look at the line item math for you for free and explain everything to you so you can see exactly where your money's going. Don't leave $30,000 on the table. The call is confidential. Protect your rights and keep your recovery. Give us a call at 866-966-5240 or visit us on our website, victimslawyer.com.